Everyone thinks they know how divorce works in Texas. What happens to the house, how custody gets decided, what cheating really costs another person. Almost none of it's true, and believing it can cost you before you ever set yourself into the courtroom. This is Texas Law Unlocked, giving you clear insight into Texas law so you can move forward with confidence. Quick note before we get started, everything on this podcast is for educational purposes only and does not constitute legal advice. Texas Law Unlocked is brought to you by the law office of Brett H. Pritchard. I'm Brett Pritchard.
I'm Jeff Linick
Jeff
with the
Linick.
law office of Brett Pritchard, and joining us is an intern from our firm, first-year law student out of BYU, Jacob Lunt.
Howdy, everyone.
He's been following us around and seeing how divorces actually work in court, and probably had a few myths of his own busted by observation.
Yeah, Jacob, how long you been with us now?
Yeah, it's been 12 weeks so far. It's been the most fantastic summer I've had.
Well, that's great.
Appreciate that.
You've done a lot with the firm. You've done lots of trials, and you've been able to sit through consults and hear some of the myths that people come in and talk about.
Oh, yeah. People will come in and they'll have lots of ideas in their head, but part of our job is to kind of give them a bit of a reality check.
Well, that's kind of what I wanted to do today. When this idea came up is we get people every day, Jeff, that come into our office that we talk to, and I hear the same things over and over again. And it's never right. And I try to correct it, but it never gets corrected. And so people come in and then seem shocked because they honestly believe the law is what they understand it. And they're shocked when I tell them that's just not the law.
Not how it works. And I don't know if it's just people putting stuff in their head or things they read off of Google, but there's definitely a lot of misconceptions floating around out there.
I think that maybe we can clear some of those up today. And Jacob did a fantastic job getting some myths together. But Jeff, you had a great idea to start. Which one do you think?
I think the first myth is that I'm not going to get a divorce. Statistically speaking, half of all marriages end in divorce, which means the other half end in death. So if you think about it, you might be one of the lucky ones and just get a divorce.
You know, it's funny, that statistic, because we've all heard that 50% of all marriages end in divorce. I was at Advanced Family. I think I've told you this, about 5 or 6 years ago, and that's a myth. And here's how that comes by. If marriage date is static for a year, if you say I have 1 million marriages in a year, then you have 1 million marriages that year. So 2026, you have 1 million marriages, you have 1 million marriages. Right. But in 2020, so then the saying goes, well, we had 500,000 divorces. Well, that's not a static number. That 500,000, I had someone come in the other day, it's been married 42 years and they're divorcing. So that 500,000 is not a static number, but an accumulation rather of many years. So when the presenter presented a study from Harvard, he said that they tried to look at the actual number, and the actual number comes out to about 23%. So still a large number, but even if it's only 23%, 76% end in death.
That's right.
They always end.
One way or the other.
So who knows? All right. Well, I agree with you, Jeff, that in any long marriage, or even a short marriage, seems to be, when people get angry at each other, that seems to be an out. Where they want to go is divorce.
That's right. And that's when they usually come see us. And sometimes that's one of the first questions I get is, do I even need a lawyer? I find that a little puzzling since you're coming in to talk to one. Strictly speaking, you never need an attorney. I also don't need a medical license to perform surgery on myself either. So while you might not need one, it's usually a good idea.
I remember many years ago when the State Bar of Texas decided they were going to put out forms for family law. They were going to do these. You could go onto their site and you could go get how to file a petition and your waiver and a decree. They have all those forms. I remember how upset that made me. I thought, why would they attack family lawyers?
Right.
That actually turned out to be the best thing the State Bar's ever done.
Right.
Because people would come in and...
so many botched divorces.
Yeah. I used to run a sign up in Gaysville that says, "Let me fix your DIY divorce."
Right.
They're always terribly done. They're terribly drafted, not because the people who are doing them are dumb. It's just it's a very complicated process, and people actually believe a lot of the myths they have.
Exactly.
And when they come in, sometimes there's nothing we can do with the divorce.
That's right. And the judge can't give legal advice. The clerk can't give legal advice. So you're kind of on your own.
And sometimes people come in on those type of divorces. We could probably have done the divorce for, $2,500, $3,000.
Right.
And it ends up costing
3 times that much to fix it.
Or more to fix it.
Right.
Once we do a motion for a new trial, those type of things.
Absolutely.
So I agree. I think that's a myth that you should always have a lawyer. That's not just with divorces either.
Right.
If you're facing any sort of legal hurdle, whether it's a family law case or civil trial or criminal, you should always have a lawyer. Wasn't it Abraham Lincoln who said, "He who represents himself has a fool for a client"?
That's right.
I agree.
Absolutely.
In my career, I've had times or in my life, I should say, has nothing to do with my career, but I've had to use lawyers and even on a case that I dealt with where CPS cases, I probably handle more of them than anybody in the area.
That's right.
And I hired a lawyer.
That's right.
Not that I was trying to adopt a child, but I hired a lawyer to make sure that my I's were dotted, my T's were crossed.
Absolutely. And if nothing else, you should at least come talk to one and come talk to us because it costs you absolutely nothing.
Right. I agree. All right. So that's a good myth. Jacob, did you come up with the myth?
Yeah.
What's one you thought about?
One of the biggest ones is the price of the divorce. People think it's going to either cost them the whole house or they think they can get it done for a couple hundred.
Yep. It's both ends we get. And Willie Nelson, I think, said it best. He said, divorces are expensive, but they're worth it. But I do, I have people come in and they're like, well, can this be done for $500? I'm like, buddy, we barely cover the filing fees for $500. Doesn't work that way. But also people think it's going to cost them 6 figures to get the divorce done. And except in extremely rare cases that it doesn't get anywhere near that much. Well,
just last week, I had someone that come into my office that I was divorcing for a second time. And I had divorced this gentleman back in the late 90s. And he comes in and he says, I tell him how much the divorce is going to be, a little uncontested divorce, $3,500. And he says, well, you did my last divorce for $500. I said, well, that was, nearly 30 years ago. The filing fee was $75.
Yeah. Gas used to be $1.50 a gallon too.
The filing fee now is $450.
That's right.
By the time you file, you get the document preparation done. You're gonna spend all of that. But I would much rather have a client come in and spend $3,500 than have them do it themselves and have to come back 8 or 9 months later, like we see all the time, having to pay $10,000 and $12,000 so we can file bills of review or motions for new trial to try to overcome what they did in the divorce.
Oh, absolutely. And if you think it's expensive, try doing it yourself or getting a second-rate attorney that doesn't know what they're doing, and you'll find out how expensive a cheap divorce really is. Yeah. And that's assuming we can fix it. Sometimes you may have property divisions that are etched in stone, and you may have given up the farm, and there's just nothing that can be done about that.
Right. Even attacking it with a bill of review or trying to collaterally attack it's not going to do anything to fix it.
Right.
It's sad. I've seen that happen a lot. Okay. Thank you, Jacob, for the myth. What about you, Jeff? What's one you can think of?
It'll be fast. People like, can we get this done next week? Now, fortunately, in Texas, compared to most other states in the country, you can actually get a divorce done faster in Texas than in most places. The only waiting requirement is that a judge can't finalize a divorce till the petition's been on file for 60 days. But even in the best of circumstances, if there's no property, no kids, parties agree on everything going into it, even still, we're at the mercy of the court coordinator, the court scheduler. So there's no guarantee it could even be done in 60, 70, 80, or 90 days in some cases. It just depends. Court could be in the middle of trial. You never know. Of course, on the other end, sometimes people say, how long is this going to take? And we always say it's kind of like asking how long is a string. It really depends. Cases sometimes they take more than a year and a half, sometimes 2 years to get resolved, depending on how much there is to fight over.
I've often said that when it comes to when I try to prognosticate how long a divorce is going to be, I'm always wrong, number one.
Right.
And number two, those that I think are going to be extremely long sometimes finish very quickly.
Right.
And those I think are just going to be very quick end up taking a very long time. And the problem with that is everybody knows, well, my Aunt Sally got divorced in 64 days.
Right.
And yeah, there might be some truth to that, but that's the exception, not the rule.
Yeah, good for Aunt Sally. The problem is you can't predict it because there's a human on the other side of the equation, and that's the factor that we don't have control over.
Right. We never know if they're going to go hire an attorney. We never know if they're going to get sick. We don't know what's going to happen.
Or they're just going to drag their feet and try to drag the whole thing out.
I've had clients, Jeff, who have come in, hired us on uncontested divorces. We have one now. She hired us in 2021 to do the divorce. We drafted the papers. We drafted the decree. We drafted the waiver. Everything that needs to be signed by the opposing party. All he has to do is put his signature on it. We've now been waiting 5 years for him to sign it. I called her the other day. I said, look, what are we going to do? Your case is going to get dismissed. We've either got to serve or we have to be done. She said, well, let me try for a few more days and see if I can get him to sign it. I'm going to have to check up on that when I go. But if at some point, what I'm going to tell her is you have to be done. You're going to have to serve him. And let's be honest, I know you don't want to spend any more money, but 5 years is long enough.
Yeah.
And the problem with us is if we carry him that long, the courts at some point get upset with us.
Right. Clogging up their docket.
Yeah. It just keeps another case on their docket.
Having said that, if you want the divorce to be done as quick as possible, the biggest thing you can do to slow it down is to try to do it yourself. Especially around here, they do have where our principal office is located, they have a pro se clinic that kind of helps people to represent themselves, but they are slow as molasses.
Jeff, I had someone just last week come into my office, and she's wanting the divorce, and she comes in and says, the reason I'm hiring you, I prepared the divorce, the petition, and I had my decree ready, and they told me I have to go meet with the pro se clinic, the pro se attorney. She goes, I set that up in March. I went and met that person, and this person told me, you need to fix this, you need to fix this, you need to fix this, and then set her for her next appointment in September.
Yep.
And she says, we'll look over it in September. Well, if it's wrong, they'll set it again in February.
That's right.
She threw her hands up, exasperated, and said, look, I just need to get this done. I said, no problem. We can take it over. We prepare it. The waiting period's done. He's on board. We can have this done and probably be done within a short time. Again, provided he wants to sign.
Right.
But that is something that happens all the time.
And I just talked to somebody actually a week ago, that couple that were doing their divorce themselves. And the other part of the problem is if you're doing anything other than just the cookie cutter, one size fits all, this is what Texas provides for in terms of property division or custody, you're going to ultimately be told to go hire an attorney. And that's what was told to this couple. And so they consulted with us. And all the guy wanted to do is kind of just flip his weekends that his visitation was, because he worked on the first and third, but had the second and fourth open. Real easy. We can do that. No problem whatsoever. We do it 10 times a month. It's very easy for us to do that. But but I asked him, I said, we can get this done very quickly. As long as we're past the waiting period, we'll get you done real quick. He'd filed this thing last August. So he's coming up on the year anniversary. Wow. I said, well, we're on the 2-yard line. I can just quarterback sneak this thing right in. You should have come see us a while ago. So if you're trying to do anything other than what the court basically assumes that you're going to get out of your divorce, it's going to slow it down, and you're probably not even going to be able to get it done. So the slowest divorce is one you try to do yourself.
All right. Well, now my turn for a myth. The myth that I hear so many, but I guess we'll start with this one. And this one is that, well, the other side committed adultery, so I win. I'm going to get everything I want. You hear that all the time, right?
If only that's how it worked.
Yeah. I think 30 years ago, or 27 years ago, when I started this practice, there was quite a, I guess, a disfavored if you had committed adultery. The judges hold that against you. I think today, if you haven't committed adultery, the judges kind of want to know why.
Yeah.
What's
wrong
going
with
on
you?
with this couple?
No wonder you're getting a divorce.
Yeah.
There's your problem.
Yeah. Judges don't hold that against anybody anymore. Jeff, I recall a story, happened last year. Two parts of it. There was the part where you handled it in court. I handled the mediation.
Right.
Why don't you tell the folks about that?
Yeah. Well, we had a client. It was the run-of-the-mill divorce. There were kids involved. There was some property division involved. But the allegation and the pleadings from the other side was that our client had committed adultery. We had the husband, and she knew it. He knew that she knew it. So there was no denying it. There was no hiding it.
He had told her in text messages, on phone, and in person that he had done it.
Yeah, and so it was out there. There was no denying it whatsoever. And even in their discovery, in their interrogatories, we just flat admitted to it. Yes, absolutely, we committed adultery during the marriage. For some reason, didn't seem to satisfy opposing counsel, so she wanted to dig through his phone, dig through his work phone, his work laptop. And so had filed all these discovery motions to start digging through this stuff, presumably looking for evidence of this adultery that's already out there in the open.
And remember, she told the judge she needed to look at the phone because she needed evidence of the adultery.
Exactly. That was the reasoning in her motion to be able to subpoena his phone, which she was going to have to take from him for a number of hours, have her expert download a copy of it, access his work laptop. It would have been a nightmare. So we get to the hearing, and she's standing up there arguing why she needs to be able to look through all this stuff. And I said, my counter-argument, I said, Judge, we don't deny it. I will stipulate on the record my client has committed adultery, as I did in our discovery response. In fact, if the court wants to know who, she's sitting here right here in the gallery. I'll have her stand up and point her out.
It was really funny. And he's like, that's her, Judge.
That's her right there.
It's who I've been sleeping with.
And I have to say, I can't blame my client.
Well, then after that, as a result of that, the opposing counsel, it doesn't matter what she does, but does something really silly, and we call her on it in a separate motion.
Right.
And we get to mediation probably the next week or within just a few days. We're at mediation. And because of what the attorney had done, and that we had called her on this motion, she was rather nervous to go back in front of the judge. So we start the mediation, and the mediator comes in and brings us the settlement offer. And I looked at my client and I said, we can take this offer right now. He goes, where do I sign? The mediator goes, oh, not so fast. It's only going to get better from here. And you can't, how do you ever tell if you win or you lose a divorce?
Right.
Who knows? But in that case, that man got every single thing he wanted, and he's the one who had committed adultery.
It didn't even move the needle.
Correct. I find that adultery has very little to do. The judges really don't care. What they care about is your behaviors around the adultery and how it affected your children.
Exactly. That's where it could make a difference.
Right. If you decide to have an affair and you're still married and you decide, oh, I want to introduce the affair to the kids.
If you get your kids calling girlfriend mommy, you got a big problem.
You got a problem.
Yeah.
I had another situation, Jeff, where we represented a dad in Williamson County, and the woman, she worked for some professional group. I don't remember who it was. And they had an arrangement that every day they'd talk about, at the end of the day, who was going to go pick up the kid. The kid was in daycare. Well, there were 2 or 3 times that Dad indicated that he had to go pick up the kid when Mom had said she'd do it, because he got a call one time from the daycare at 5:30. The kid was supposed to be picked up at 5. Where is she?
Oh boy.
Well, he couldn't figure out what was going on, so He thought maybe something's wrong with this. Is how he found out about the affair. Looks at his Life 360, goes and picks up the kid, and then drives where he is. She is at her employer's home.
Mm-hmm.
And later that night confronts and says she admits to having an affair. The judge in that case was incredulous that she would miss picking up the kid from daycare so that she could carry on with her tryst. Didn't care about the adultery, cared about the actions around the adultery. Judge gave custody to the father.
Yep, absolutely. That's where it'll absolutely wreck your custody order that you get out of the divorce.
Yeah, that's the problem.
Right. Another thing that's changed, that just popped in my head since I've been practicing, is it used to be common to have something of a morality clause in the divorce decree. Oh, yeah. Those have kind of completely fallen out of favor. Once the divorce is done, parties are moving on. That's just the bottom line.
It is. I tell my clients all the time, when they come in, they're worried about who the kids are seeing when they're over at the other parent's home. I tell them, what happens at dad's house is none of your business.
Right.
And what happens in your house is none of his business. Who you see, what you do. The courts have come out and essentially said that parents act in the best interest of their children.
That's right.
And so parents are going to get great deference in who they have their kids around, because it's going to be, the courts are going to look at that and say, look, this father is not going to allow his kids to get hurt. And so, mom, it doesn't matter who he has the kids around. And dad, mom's not going to allow these kids to be placed in danger. So it's not going to matter who she has the kids around.
And the truth is, it never really ever was about the kids. It's the person being jealous that they've moved on is what it really comes down to. So the courts have just decided that we're not going to wade into that. It's not worth it.
Yeah, you don't see those in final divorce decrees. You do see them still in the standing order, I think.
Right, sometimes.
A little bit in the court standing orders. But all right. Well, one that I see every day without fail is, because we live next to a military base.
Yep.
Is, well, we weren't married 10 years, and so the spouse is not entitled to any of the military retirement. How many times you've heard that?
More times than I can count.
How many times, Jacob? You've done consults now. Have you heard it?
Yeah, every time a military guy comes in.
100% of the time. Or I'll say, okay, well, she's entitled to a certain person. Well, she's not been married to me for 10 years.
Right. You think the military personnel themselves, of all people, would be the ones that know that. So I don't know how that myth got started, but it spread like wildfire. Everyone seems to think that.
Well, we call them barracks lawyers.
Yep.
Right?
That's true.
Everybody in the barracks, they're sitting around talking, getting a divorce, and they say what they believe the law is. That's been going around for years and years and years.
Right.
The truth is, retirement begins to accrue the day you're married.
That's right.
And every day that you're married, your spouse is entitled to half of the retirement that accrued that day. Mm-hmm. Pretty soon days become months, and then months become years. And then we're able to divide that. Now, there is truth in this. At 10 years, DFAS will cut a separate check.
Right.
We'll withhold it from the retirement and cut a separate check to the other spouse.
Right.
But
that's just a convenience matter.
Right.
That just stops you from having to write the checks yourself, basically.
Right. But prior to 10 years, the other spouse is still entitled to their portion of the military retirement. The only difference is you have to scratch that check.
Yep. And it's shocking how many people think that both military personnel and non-military personnel, and crazily enough, even some lawyers think that inexperienced ones are ones that don't know what they're doing. And we had a case where this involved our senior litigator. The party on the other side, I know you probably remember this one, wasn't aware that her client was entitled to our client's military, and drafted up a Rule 11 or an agreed decree where our client was keeping everything. We're like, well, our duty is to our client. We're not saying a word.
I remember that.
And I hope that lawyer has their malpractice insurance paid up.
Yeah,
we just got a windfall.
Hundreds of thousands of dollars.
Yep. And we just kept our mouths shut, and he walked away with the whole thing.
Yeah. That's also going back to what we talked about. If I've seen in any DIY divorce, the biggest mistake I've seen is division of retirement, not
Yep.
just military retirement, but all of it.
Yep.
Spouse is saying, well, we were married, he earned it, I'm going to give it to him. When I bring him in and I show them,
Do the math.
you do the math and you extrapolate that over the next 41 years, you just give it,
in most instances,
always
it's the
the
highest
highest
value
asset.
asset in the entire marriage.
even more than
Yeah,
the house, because those
absolutely.
things are sometimes they're $500,000-$600,000. You're walking away from that, and if the calculation's wrong, you're missing out. If you include it, if you include the language incorrectly.
Right.
We had a case the other day where in the property division, you'll recall we were going to have to file. We tried to file an enforcement. She had put a provision in the decree regarding spousal support.
Right. That's right.
Do you remember that?
Yeah.
And how she was entitled to this and this, and what it came down to, because she had done it all wrong, it was nothing more than a contractual alimony claim.
Not enforceable.
And not enforceable by contempt.
That's right.
She walked away from the retirement thinking she was going to get this money that now he walks away from, and there's nothing she can do.
It's sad. Very sad.
Yeah, we got the decree and we called her back into the office and we said, we're sorry.
Yeah.
There's nothing, and a property division is one of the things you can't modify.
Nope. That's done.
And because it was 4 years old, we had no options at that point, nothing we could do. I felt terrible for her, but what do you do in that situation?
Yeah, it's a sad situation.
It is. All right. What's another myth? You got a whole list of them.
See, just a question that comes up. I don't know that I have any good stories about it, but people always ask me, should I be the one filing first? It makes no difference. It's just a question I get all the time. I don't know if people think there's an advantage to filing first, or sometimes people think maybe it makes them look bad by filing first because they're the ones asking for the divorce. It makes no difference. If we file first, great. If the other side's already filed, we file an answer, we file a counter petition. It makes no difference.
I think it's important to understand when you file first, you're filing a petition.
Right.
It's called a petition for divorce. If you get served and you're filed with a petition, what we're going to file is a petition for divorce as well.
Exactly.
Now, it's called a counter petition,
Right.
but it's the same thing. And over the years, I've tried hundreds of trials, dozens upon dozens of jury trials dealing with custody. And I have tried over the years to think, is it better if I go first or if I go last? I've won jury trials both ways, and I see advantages to both.
Right. That's the only place it would make any difference, is just in the order of which side presents their case first to the judge or jury. That's just a legal tactical question. And we've been on both sides, and it really makes no difference.
It's immaterial. In fact, towards the end, I remember one of the last jury trials I did, I think we were the counter petition, or we were the petitioner. And I went to opposing counsel and said, hey, listen, we're the counter petitioner, but if you want to go first, by all means, go. And the reason I did that is I thought in that case was, I'll let this person get all their witnesses out. They'll get all the heavy lifting. I won't have to worry about calling as many witnesses because the facts will be out there. We won custody, but it turns out it didn't really matter.
Right.
Whether I go first or I go last, it's immaterial. I don't care. That's never been an issue. So that is a good myth. Jacob, what's another myth you thought of?
Yeah. I think a lot of people think that if they don't disclose something, whether that's an asset or something, some behavior from their past, that it's not going to come out in the divorce.
Ooh, that's a good one.
Boy, that's one of the most dangerous myths, I'll tell you right now. You got to think you're on the opposite side of a court case with somebody that you've probably been living with for years, telling all of your secrets to for years, knows where all the skeletons are buried, and probably actually knows more than you think they know, because even things you've been trying to hide, they're probably well aware of. And if you think trying to bury something is going to save you, it's only going to make it 10 times worse, because when it comes out, then you're going to get a double whammy, and you're probably going to wind up not only taking the blow, you're going to wind up paying someone's attorney's fees.
And we have to know.
Yes.
The one person you can't lie to is your attorney.
Right.
Your attorney needs to know, and you've got to be truthful with your attorney. I remember representing a person, we'll call him Jack, and Jack comes in and wants custody with the mom. and Jack tells me, I want her drug tested. And so I tell my client, if you're getting her drug tested, you're going to be drug tested.
Mm-hmm.
And Jack goes, okay, I'm ready. So I said, you promised me you're not going to fail. I won't fail a drug test. Okay. We go in. The other side starts, tell the judge, we want a drug test. And the judge says, I think that's a good idea. And he says, I'm going to order every person here to get a 20-panel, back then it was 16, a 16-panel hair test. And he starts pulling on my jacket.
I remember this.
And I'm like, I been over, I covered my microphone. Jack, what do you need? He goes, I can only pass a urine test. And I looked at him and I sat back down. I said, I asked you if you'd pass. Well, I thought you meant urine. That guy's the first guy I ever had. He popped hot 16 of 16. Every single drug that you could possibly test hot for, he tests.
He's probably hoping they'd all cancel each other out.
So yeah, that's probably another myth that you can try to hide things. Thanks, Jacob. That's a good one. Jeff, what else do you have on your list?
Oh, mom always gets primary custody. Way back in the early days, that might have tended to be some truth to that, but now
back until about 85, 87, somewhere in there. In Texas, it was presumed
right. There was
to be in the best interest of the child for the child to live with the mother.
Right.
Now, Jacob, you're in law school. What is a legal presumption? Do you know?
A rebuttable presumption?
Yeah. What's a rebuttable presumption? What's a presumption?
It just means that's what the court's going to assume until you get some other evidence in there.
It's more than assume. A presumption says the court must do this unless we can rebut that with credible evidence. So in those old cases, back before the 80s, the court had to start with
mom gets the kids.
Mom gets the kid.
And dad had the uphill fight to overturn that presumption.
When I first came on to practice in 1998, the presumption hadn't been away for very long.
Right.
Judges were still on the bench that followed the presumption.
They did their whole career under those rules.
Attorneys that were my age had spent their entire career under a mother's presumption. That took a while to turn.
Right.
By about the 2000, 2010, that time frame, that stopped.
Most of those judges are now retired.
Yes.
I say most. There's still a few real old timers, but
the judges that are on the bench, at least that I've seen, are usually around my age or younger.
Right.
And we were not raised with the mother's presumption.
Right.
We were raised that the court shall not consider the sex of the parent when determining which child or which parent should have custody of the child.
It is codified. The Texas Family Code is explicitly gender neutral in that regard.
Yeah, that's a great myth.
And we represent dads all the time. I mean, it's just the standard is merely what's in the best interest of the child. And there's plenty of dads that can provide a great home environment better than the mom can. It happens all the time.
In where we live, I think may not be a myth, but I think the better way to gauge is if you have two otherwise good parents, good people. Maybe they're bad for each other, but they're good parents. And one of them is a service member. Even though we love service members, heck, my dad was a service member, retired. That's why I live in Killeen, because I love working with our service members. But being a service member, whether you're the mother or the father, against a non-service member, those are the hard cases to win.
Those are, because they do have to move around a lot, and that does make it tough.
Service members can be deployed.
Yep.
They can go on alert. They have TDY, they have schooling, they have staff duty or CQ. They have all these things that take them away from the home. And they might have to go on an unaccompanied tour to South Korea for 9 months, or they get deployed for 9 months. And unfortunately, you can't take your kids to the war zone.
Exactly.
Or maybe that's fortunately.
Yeah, right. I mean, and there are a lot of them that just say they understand, the other parent probably it would be better for the child to reside there. Having said that, there are definitely scenarios where the other parent would not be the place where the child should reside, and we've won cases where we've represented service members.
Of course we have. The number of cases, that just facts really dictate that. I said if you have two, my scenario was if you had two
Right.
otherwise good parents. If you've got one of the parents who's in the military and the other parent is strung out on drugs, well, the military member's going to win.
Right.
And it doesn't have to be strung out on drugs. If clearly one parent and they're in the military is the better parent, they can win custody.
Absolutely. And if nothing else, Uncle Sam's going to make sure that you've got a roof over your head and food to put in the kid's mouth, and that sometimes goes a long way.
Jacob, give me another myth that we can talk about.
Yeah, I think there's a nugget of truth to this one, but people blow it way out of proportion. They think their case is really unique, whether that's their spouse is particularly crafty.
Let's do that last.
Okay.
That'll be the miscellany. I've got one.
Okay.
Your kids can't handle a divorce, and so had a lady come in one time for a consultation, and I was just trying to get some basic information. And she asked, and I asked her, I said, are there any kids from the marriage? And she goes, "Oh, you mean besides my husband?" And so what I've observed is divorce is the one kind of practice of law where the parents sometimes turn into the kids and the kids sometimes turn into the parents. And just my observation is kids are often a lot more resilient than I think we give them credit for. And of course, we in the courts do a lot to try to insulate the kids from the proceedings and to try to keep things as stable as possible for them during the litigation to insulate the kids as much as possible. But that is one thing that you really can do damage to your case is if you try to insert the kids into the middle of a divorce. I've got a story on that one. So I had a case where I represented the wife, the mom, and dad had earlier split with the kids, and we actually had to track him down and find him and file the petition, get him served, get into court on temporary orders. And I was representing the wife. Dad shows up to court representing himself. It's never a good idea. He brought an iPad with him. And at one point during the hearing, again, he doesn't know how to get evidence entered, so they always just blurt out what they're trying to do. I've got this video I have of our child, and she doesn't want to live with mom. I'm like, okay. So the judge kind of walks him through. Okay, so you wanted to introduce that as respondents one. Yes, judge, that's what I want to do. So then he has to get it admitted. Now, judge asks the other side if there's any objections. There's probably about 16 million different objections I could have made under the family code or the rules of evidence. And in most cases, I would have. But in this particular case, I said, Judge, there will be an objection. It just won't be a legal objection because I'm curious to see this, as I imagine the court is as well. So the judge he hits play on that sucker, and it looked like a hostage video. He set this iPod or tablet on a tripod, and the girl's standing there in the living room holding a teddy bear, and you can tell he's off to the side because she kind of glances over in between what she's saying, and she's like, I'm afraid of my mommy. I don't like her. She's mean to me, and she's mean to my daddy, and she makes me cry, and she makes him cry. And the bottom line is not only did my client wind up getting the kids back immediately, the final order in the case was his visits were to be 2 hours on the weekend, supervised. The supervisor had to be within earshot of at all times. And the judge even said, if you've got to help her go to the potty, you need to leave the door open so the supervisor can hear what you're saying. And you're not to discuss anything about the case. You're not to discuss why she's only seeing you for 2 hours. You're not to discuss why there's a supervisor. Mom will explain all those things. And you're absolutely not to make any disparaging remarks about mom. And that's in the final order. If you don't like it, you can file a year later and we'll revisit it at that point.
I had a case very similar, Jeff, where we had kids. We were in Coryell County, and there were two kids that the other side wanted them to confer with the judge. And the father had come in, I had the mom, accusing the mom of using drugs, and mom says, I don't use drugs. And he says, Judge, you can talk to the girls. The judge takes the kids in chambers, and when she comes out, she looks at the man and she says, you're not getting custody. And we're like, what happened? And so the judge on the record says, I did bring the girls in, and I asked them if their mother does drugs, and they said, our mom smokes marijuana. And I asked them, how do you know that? And they said, because our dad told us.
Oh boy.
So those type of things do happen.
Absolutely.
Kids can't stay in the middle. I also I thought of another funny story as you were talking about. Sometimes our clients are the ones that are acting like kids. I recall in a case in front of a great judge we had in Bell County. There are videos. My lady is walking around. She's yelling, and the husband is walking around videotaping her as she's yelling, and she's like, turn that thing off, just yelling, screaming, get it out of my face. He's like, I'm allowed to record. They're just at loggerheads.
Yep.
She's yelling. And so he introduced, I don't know why, but the other side introduces this to show that my client's a hothead. And I remember the judge going, what did you expect her to do? How many times does she have to tell you to put it down?
No kidding.
And then he goes, I want to talk about the kids in this case, and I'm not talking about your children.
That's great.
And so I don't know why that happens in a divorce. I a lot of times will tell my clients when they come in and I see that, I'll say, you guys are calling each other's names. You're doing these little slap fights.
Yeah.
I said, we teach our kids that you don't call names and that you keep your hands to yourself. And you two are acting just like what you tell your kids not to do. Stop it. Stop it. All right. Another myth. Jeff?
Oh, this probably follows onto that. Your ex is horrible. Maybe, but if you have kids together, you're going to be co-parenting for the next however many years until your kids turn 18. So if your position to the judge is this is not somebody I can ever talk to or work with in any capacity, it's not going to look good for you because the court expects you to be able to co-parent. The family law presumes it is in a child's best interest to have as much contact with mom and dad as possible and for the parents to work together to make that happen.
That hit me square between the eyes one time in a case that I had when the same thing. They just, judge, I can't work with him. I can't work with him. And the judge stops the hearing and he goes, you do understand the following. When your child goes to kindergarten graduation, you're both going to be there. When your child goes to high school prom, you're both going to be there. When your child goes to graduation, you're both going to be there. But then he goes, and that's to 18. Then when they get married, you're both going to be there. And when the grandkids come, you're both going to be there. He says, you have a child together, you will spend the rest of your life with the other person. You might as well learn. And he said this, he goes, you don't have to like her.
That's right.
You don't have to love her. You don't even have to like her, but you're going to have this business relationship because you are in the business of raising a child together. I'll never forget that. I've tried to give that advice over the years. Just bury the hatchet.
Yeah.
When the divorce is over, it's over. And you're going to have to learn, if you have a child, to get along or to at least bury the hatchet, work together as a business relationship, or it's going to be terrible the rest of your life.
Yeah, absolutely.
It's never going to get better. And what I have found over the years is that the children don't like that either.
Right.
When the parents are fine like that, eventually the kids won't invite you to the wedding. They're not going to invite you over for Thanksgiving because they just don't want the conflict that comes from having parents that
who wants
can't
to
get
be
along.
Who would want to be around that?
Yeah.
Yeah.
I can't. So it's really important that if you're in that situation after divorce, look to yourself. What can you change in yourself? You can't change the other person, but how can you change yourself maybe to make things better if it's possible?
Right. And we try to craft the court orders as specific as possible to give people a common playbook to work off of to try to minimize the conflict they have.
All right, I got my myth.
Okay.
You ready?
Yep.
Here it is. The other side's a narcissist.
Oh boy.
And the other side is alienating my kids. Hey, if I had a dime for every time I heard the other side's a narcissist, I would be a very, very wealthy man.
Yeah. Everybody's an armchair psychologist.
Yes.
In fact, there's no non-narcissists out there, apparently.
Yeah. I've never had a divorce where the other side's not a narcissist.
Neither have I.
I mean, we ought to call, it's the craziest thing. Every time, almost every single consultation.
And
I hear that.
And I don't know what they expect me to do with that. Just in the middle of hearing, hold on, Judge, hold on. Here's what you got to know. The other party, they're a narcissist. Oh, well, that changes everything then.
Well, not just that, but what I have found in that's actually funny. Yeah. What I found in court is judges don't like hearing one party say that the other side's a narcissist.
Well, they've heard it a million times too.
Yes,
That's the problem.
Frustrates them. The judge, you're coming into a divorce, and the judge has heard thousands of divorces, probably tried thousands of divorces, and has heard that mother's alienating the affection of the child or dad's a narcissist. And I tell my clients, you will never hear me use the word alienation. You will never hear me use the word narcissist. I will go to the court and I will give evidence of behavior, and I'll let the judge draw her own conclusion.
Even if they are alienating the child, I just show the facts. I wouldn't use that word.
Right. Because the minute you use that word, the judge goes, nope, quits listening. Yep. So when I tell my clients this all the time, when you come in and you tell me the other side's a narcissist, I figured. I mean, you don't have to tell me that. Right. So I don't want to hear that he's a narcissist. Give me facts that I can go to the judge and let the judge draw her own conclusion.
Exactly.
Right?
Yeah. Evidence is what we present. Judge will draw the legal conclusion.
Correct. Or the medical conclusion.
If that's right. If you can give me an expert diagnosis from a licensed psychologist, maybe then maybe. Even still, I don't know.
In my nearly 30 years of practice,
but I've never seen that once.
Never seen that one time.
Not one time.
I've never seen anybody diagnosed.
I've never even heard of it.
With narcissistic personality disorder. I've heard of it, but most of the narcissistic personality disorder, he gaslights me. He does this. He does this.
Right.
A lot of that is just child petulance.
Exactly.
Childish petulance that people do to each other when they're going through a divorce because they're mad at each other.
Yep.
Right?
Yep.
All right. Another myth.
Oh, let's see.
I think a big one is people think they can get out of child support in a bunch of different ways.
Can I just sign my rights over and not have to pay child support?
That's a big one. Thanks, Jacob.
There's something called the AG's office, and they wouldn't be anybody sitting in the courtroom if it was that easy.
You know, we hear that all the time. Well, I just want to sign my rights away because I don't want to pay child support. Well, my goodness, if we could do that, I mean, we wouldn't have anybody paying child support.
That's right.
Everybody would sign their rights away. Look, the reality is this. You can't hide from child support. I've had people that have come in to the non-custodial parents who have tried to quit jobs, who've tried to change jobs, who've tried to work under the table, who've done all these things. And I recall one time a person who did work under the table. This person was, in this case, the dad had to pay child support. He was a contractor and he didn't file taxes and he did everything cash. Everything cash. Well, what he failed to realize is that when I do discovery, I get to know what they have. And guess what? The mom knows who I represented. The mom knows what you have.
Hey, you'd be surprised how often people blast it on Facebook, their fancy cars.
So here was a guy with a brand new car, those type of things. He shows up to court. We're in front of court.
Tries to plead poverty.
Yeah, he's like, Judge, I don't have any money coming in. I don't have any money. And I looked at him and said, how'd you get here today? Well, I drove. What car did you drive in? And that's when I realized, 2006 Z10 Corvette. You have a payment on that? No. You paid cash for that? Yeah. Judge, we'll just take the Corvette.
That's right.
The judge goes, how do you afford a Corvette? He goes, Mr. Pritchard, what would the payment be on a Corvette? I said, Judge, I don't know. It'd have to be a couple grand a month. Says, I think so too. $2,000 child support. Was able to quantify it. And so I think it's a great myth that I'm going to quit my job so I don't have to pay child support.
Even if you intentionally make yourself poor, it doesn't matter. There's a case that went to the Texas Supreme Court where an individual was a petroleum engineer and went and got a job at McDonald's to lower his child support. The case law is clear. They can base your child support on your earning capacity.
That's now that's actually codified. You can be intentionally underemployed or intentionally unemployed.
Right. Not going to lower your child support.
Okay. With child support, here's a myth. Well, we'll say mom gets child support. She uses child support. She doesn't use child support on the kids. She uses to go get her nails done.
Right. Like you're expected to get a line itemization of everything that's being spent. It doesn't work that way.
The seminal case comes out of when I was in law school about child support, where the other side accused the mom of using the child support money to buy drugs. That's what the accusation was. And the court came out in that appellate court opinion and said, child support is not for the benefit of the child, is to reimburse that parent the added expense of having the child there full time. So what that parent uses the child support money for is immaterial.
That's right.
And doesn't matter.
And money is fungible anyway, so it's not your child support is earmarked for anything. It just goes into a bank account.
Right. You can. How do you know which one's being used? All right. There was one more you want to talk about. Unique.
Oh, yeah. My case is unique. So we've probably seen it all at this point. I've got a little miscellany of things that a lot of these are just recent. So I've had a case where two married people were involved in a throuple. So there was a third person that was involved, not technically married because that would be illegal, but all over a lot of the property items. I had a case a long time ago, early in my career, where somebody married a stripper, and prior to their marriage, he had bought her fake breasts and tried to argue that they were his separate property and wanted to get them back. Bottom line is it was a gift, so he
I
gave
had
it away.
a similar case. Remember with the fake teeth?
Oh,
She
yeah.
had bought him dentures. This lady had been married several times, and she had married this gentleman, and he didn't have any teeth. And she decided that she was going to buy him some fake teeth, and so she did. Well, it comes time to the divorce, and she wants the fake teeth back. The only issue left, and a good friend of mine is Steve Walden, and Steve Walden is trying this case with me, and I don't think Steve would mind if I used his name because this was a funny story. I come in, I say, I represent the wife, and she wants the fake teeth back, and we start arguments, and we're in front of the judge, and Steve makes his argument, and I said, Judge, let me tell you why Mr. Walden's argument has no teeth. And then he stops and he looks at me, and the judge looks at me, and he goes, Judge, that argument really bites. And we start making jokes back and forth about teeth. And the judge, the whole time,
His position is just hanging on by the skin of his...
skin of his teeth. No, we actually said it. And the entire time, the judge is sitting up there, and you can tell he's laughing because he's sitting with a straight face, but his shoulders are going up and down, trying not to laugh. He finally stops and says, all right, and he makes some quip about teeth. I don't even remember what it was, but I actually need to go get that transcript.
We should.
But I should. But he makes some quip about teeth, and then we all leave. He keeps his teeth, of course, as a gift, as separate property.
Right.
He says, he said something about the root of the problem or the root of the issue is the root of the issue is that this is a gift, and so everybody leaves.
And don't look a gift horse in the mouth.
Yeah, who knows? So he calls us both forward after they all leave, and he says, "Listen," he goes, "that was more fun than I've had in a long time, but next time that you're going to do that, let me in on the joke beforehand. I have to sit up here with the form.
Don't break them up in the middle of a hearing." We've had a case just this year where somebody was an Iraqi national. I think they had dual citizenship, and they had taken the kids to Iraq, which is not a signatory to the Hague Convention for the Protection of Children. And we had to catch them flying back in the United States with an attachment writ to get the kids off the plane when they touched down, so he doesn't take them back to Iraq. We've had a case very recently where we represented the husband, where the wife was served, but then kind of took off with the kids. The kids are not the product of the marriage, and we have to prove that. But we can't find the kids to get a DNA test. The husband, however, is a trans man, is actually biologically female, so we make the argument on biological impossibility. despite what we said earlier, finished a case this year where we were actually able to have somebody relinquish their parental rights in a divorce. So it's rare, but there is actually a way it can be done if you have a very good attorney. Nothing wrong with the dad, but mom didn't want him to be involved. And so we got a divorce where his parental rights were ultimately relinquished and mom kept the kids and he didn't have to pay any child support. So most of these are just in the last few months. And how many divorces would you say we've done over the years?
Oh, we've done 30,000 divorces or family law cases. Jeff, I find that uniqueness in a divorce, what a client, when they come in and say, I have a unique position, what they're coming in to tell me is I'm very confused about the process. And I tell my clients all the time, a divorce really, let's simplify. I said, I tell my clients, I like to back away from the divorce and back away from the minutia. They're in a divorce with kids. There can never be more than 7 issues. Property, or with the property, you got property debts, spousal support and retirement. And then with the kids, custody, child support, and visitation.
Right.
Those 7 issues, never more than that.
Right.
Now, what I tell my clients is we're going to be laser focused on those 7 issues. All the other things all the other minutia you need to figure out where does it fit in those 7 issues.
Right. Because they usually want to just come in and talk about how bad the other person is and how unbearable it is to live with them. Unless it applies to one of these 7 things, really doesn't matter.
Which is why, at this point, I think when we go back to what we talked about for adultery, why it probably doesn't matter in the end, unless, as we said, when you're looking at custody or visitation, if the affair itself is immaterial, it's the behaviors around the affair affects the custody, right?
Exactly.
So we're going to, when an attorney comes in or when a client comes in to speak to me and they start giving me the minutia, I say, okay, how's that going to fit in here? What am I proving if I can prove that?
Right.
If I can prove your husband is a narcissist,
what does that do for us?
What does that do for me? How does that affect me in this case? A lot of times it doesn't.
Right.
It's just someone being upset. So that's why people hire an attorney, is because we can look at them and say, hey, look, we understand your hurt. We understand the tender feelings you have. We don't know you. We don't have that. We can step back from like 30,000 feet and
Right.
say, that's not really going to help you in your divorce.
We can look at it objectively, and our job is to filter out the relevant from the irrelevant, and we can always focus on the issues that matter and get you through the process and get you a decree that's going to work with you for the rest of your life.
That's what we hope.
We hope.
We hope we can get it. All right. I think I've got most of them. So if any of this sounds like where you are right now, don't make a decision based on what you heard from a friend, a forum, or a Facebook group. Don't even make your decision on what you heard from here. Talk to someone who actually knows family law. Give us a call. I'm Brett Pritchard.
I'm Jeff Linick.
And this is Texas Law Unlocked.